So, I'm wondering if next we could maybe go into. You mentioned, so we just talked a little bit about non-payments, and hopefully that's going to, some of that information is going to be coming about what the next steps are going to be. Is going to be coming out with this new bill. Do you want to go into a little bit of what you mentioned at the beginning, this idea of essential evictions? Are there, what are the cases where it's actually appropriate right now to move forward with an eviction?
Yeah, the biggest thing I'm also seeing right now is issues having these for-cause evictions pop up that relate to just criminal, unsafe, unhealthy, abusive behavior, especially in the context of landlords that have duplexes, where you have tenants sharing common space, where you have obviously condo units, boarding houses, sober houses, folks that have been just living in close quarters, they've been quarantined, and sometimes you don't have the most emotionally stable folks. Well, it's not a good time for emotional stability, but those issues are rising up. The tenant versus tenant fights that are causing a lot of problems for landlords, and the landlords are stuck saying, well, do I leave it up to the tenants to figure this out themselves? And do they go get harassment prevention orders against each other? How does the landlord really police that? So I get a lot of those requests, and it really depends on how the behavior, how elevated the unsafe, unhealthy criminal behavior is to necessitate or to allow a for-cause eviction to go through. And I'm just seeing a lot of these, a lot of the infighting. And if you're having police visits to the property, if you're having people being arrested, if you're having actually one tenant get a harassment prevention order against another tenant, then the ladder rises up, the water rises to the level necessary to start the essential eviction. If it doesn't rise, if the conduct doesn't rise to an essential eviction, I usually advise a landlord to at least send out a warning letter. Send out a letter to these folks saying this behavior is not going to be tolerated, this behavior can jeopardize your tenancy, and issue them a written warning. That's the least you can do. It's not against the law, and at least it allows the landlord to paper the file. And if the landlord has to bring an eviction case related to that issue, the landlord can at least say, well, I warned the tenant in writing before, and they continue to display this poor behavior. But when, again, you have that behavior where you have tenants really significantly impacting the health and safety of others, and it's happened, I've had a few, then we do issue a standard notice to quit. So it would be a for-cause eviction, and it depends on what your lease may state. For cause eviction notices, some leases have 7-day notices, some leases have 10. If you have subsidized housing, which I think HAC has a lot of those, you're going to have to follow more of the Section 8 federal guidelines and issue a 30-day notice to quit. And if the tenant hasn't vacated at that point, then the housing court, which is where I'm bringing these cases, in the Southeast Housing Court, they will allow a landlord to submit a summary process eviction complaint for what's called this essential eviction. And many landlords are going to have, it's going to be a completely different scenario in court right now, because the public isn't really allowed in. Actually, in fact, they're not allowed into the courts right now. And you're going to see the courts slowly reopen on July 13th. Even most attorneys can't go in, but a standard summary process Thursday and Wednesday day are going to look quite different for the near future. In fact, the housing court is not intending on having any in-house matters here in Barnstable. All hearings are now being done by Zoom.
I was going to say, so you've for the last couple of months, you've been doing all of your hearings just like this.
That's exactly right. With the judge here, my client's behind me, and then I have witnesses lined up on the phone who have to then jump in on the call.
Oh, wow.
So it's worked. So housing court for these essential evictions, and I imagine this is going to happen when the law expires, for all evictions, for the short term at least, you're going to have to e-file. Landlords are going to have to figure out how to e-file their documents, which isn't too difficult. And then the court the clerk's office is going to screen in the beginning whether or not the cases coming in right now are deemed to be essential. If they're screened as yes, it has that potential, the case is permitted to be filed. And then the courts, believe it or not, they send out a Zoom hearing and they contact you. They contact the landlord and myself, and they try to arrange for a Zoom mediation conference.
Oh, wow.
Before the hearing gets scheduled. So much like many landlords and tenants are used to, you go into voluntary mediation in the
Right.
mornings of the process. You still have that opportunity, at least in housing court, to do that. And then if you can't solve it at mediation, you go in front of the judge on Zoom, and the landlord has to be prepared to meet their case, and more importantly, prove that what's going on here is unlawful, unsafe, unhealthy, criminal behavior. And it's the landlord's burden to prove that. And if the landlord proves it, then the tenant will be asked to leave, and the judge will have to give a time as to how much. The judge will have to give a time for the tenant to move out.
Okay.
So it's a completely different.
You said on July 13th, courts are opening again. Although it sounds like only on a limited basis, you're saying?
Very limited. I don't think they're going to open. In fact, I know they're not. They're not going to open for normal landlord-tenant cases. I think you're going to see them open under really tight occupancy limits for criminal matters and some civil stuff. But again, the courts are encouraged to conduct as much as they can telephonically, through video, through Zoom. So I think that's going to be the normal standard.
This is going to be the new normal that people are going to have to get used to doing, even going forward, probably well into the fall and maybe next year, it sounds like.
100%. And then the other issue is jury trials, because many tenants, as landlords know, they have a right for a jury trial, and that creates a further delay. And there's no current plan in place yet to accommodate a jury and to impanel a jury. So that's a big question mark that's going to have to get ironed out.
That's really, really interesting. I mean, it's fascinating to me how society is kind of changing as a result of this, and in the way that we all work and interact. And it's been interesting to see how things, even after this is over, hopefully not, it's not too long, but it'll be interesting to see, what changes to the process end up sticking permanently.
Yeah, it will
Or
be
we'll just
very
go right back to the old way. I don't know, but.
And it's also going to be interesting, David, to see how the court handles just the massive backlog. There were thousands of eviction cases already in the pipeline when this law hit. So those have all been frozen, in addition to all the eviction